Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our July 15th public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multiple dwellings from commercial and manufacturing spaces to safe, rent-regulated residences which comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. I have one short announcement to start. This is the first in-person meeting of the Loft Board since February 2020, believe it or not, soon after which the coronavirus pandemic forced us to do remote meetings. I appreciate everyone's patience as we hold this in-person public meeting while also maintaining COVID-19 related health and safety protocols. In addition to this in-person public meeting, we are streaming the meeting to the public via the internet. So that our equipment can best capture all of the comments spoken today, I ask that everyone who speaks, which is a member of the board, please speak slowly and clearly. A microphone can be passed to anyone who wishes to speak. We first turn to a vote on the minutes from the June 17, 2021 public meeting. Are there any corrections or comments to these minutes? Mr. Delaney.
Yes, I have one question. I did send you one typo. I presume got incorporated.
Mr. Delaney, 1 second. The microphone.
Is that Mr. Approaching topic? Hold it for a moment. No, hold the button. Sorry.
There's a red button. There's a button on the side somewhere. Here, Mr. Delaney. Mr. Delaney.
There, that's now we're good. So yes, I did send one typo to the executive director. In the discussion that we had last month on professional certification, on page 16, Chairperson Hilton states that the Department of Buildings does not issue architects and engineers their licenses. That is done by the Department of Education, under the Board of Regents. So all we can do is refer our cases to them for discipline. And just for clarity's sake, do we in fact refer cases to discipline to the State Department?
Yes.
Yes, okay. Thank you.
The department, not the law. The Department of Buildings, correct? You talking about?
Yes.
Yes.
Thank you.
And yes, the edit that Mr. Delaney noted will be reflected in the final minutes that are published. Thank you. Which, just for the record, is the change of the word voluntary to voluntarily.
Yes.
Thank you for noticing that.
Thank you, Mr. Delaney. Are there any other corrections or notes on the minutes and comments on the minutes? Absent comments, Ms. Rivera, could you please poll the board members?
Motion.
Motion, excuse me. A motion to accept the minutes. Mr. Roche has made a motion. A second to the Mr. Roche. Anyone second?
Second.
Ms. Ayashi. Thank you. Ms. Rivera, please poll the board members.
Mr. Roach.
Yes.
Ms. Hashi.
Yes.
Mr. Delaney.
Yes.
Ms. Roseland.
Yes.
Ms. Adams. Yes. Ms. Rajan. Yes. Chairperson Hilton.
Yes.
7 in favor, 2 absent.
Thank you, Ms. Rivera. Mr. Schultz will now do his executive director's report.
Hello, everyone. Thank you for joining us today. I want to start my remarks with a quick but very sincere thank you to the staff, the facilities people, the IT people, law department, who all were back in an in-person meeting today, which with the confluence of open meetings law and COVID requirements is a greater feat than a normal meeting. And we couldn't have done it without a lot of people acting pretty quickly to put this together because of all of these circumstances. So thank you to them, and thank you to the public who were joining in through streaming, for their patience with the technology, and the people in the room for their patience with the different setup we have. With that, I'll move on to related to that. As of June 25th, the Governor's Executive Order 202.01, which suspended the in-person meeting requirements of the open meeting law, was not extended. As a result, this July 15th, 2021 meeting is an in-person meeting, and to know public health guidelines for indoor gatherings will be followed here today. The unofficial Loft Board revenue for June was $2,225, and I'll note that we are in the midst of our annual registration, which is when the revenue increases significantly. With respect to annual registration, our staff is underway in processing that flood of paperwork and payments, and we will have an update in September's meeting on that. And I'll also just note that a letter was included in the annual registration to owners from the executive director and myself, advising of the enforcement mechanisms and the rules, and that late submissions are subject to penalties, and that the Loft Board will be utilizing these mechanisms toward compliance and accountability in its annual registration process. Our enforcement attorney is already priming the meeting materials to follow through on this. So annual registration is important. The rules for compliance are important. So we've gotten a lot of compliance, and we're very pleased with that. And as the deadlines of the month continues, we hope and expect to get compliance.
Mr. Schultz, has been quite good responses so far? Has it been good?
169.
169 responses thus far. I think 300 is the number, roughly 300 is the number of our buildings.
And their deadline is?
The late fees accrue at the end of July, July 31st or August 1st. Operative date is one of the two. So yes. Regarding enforcement, on June 28th of 2021, 2 violations were issued for 112-114 West 14th Street. Is this a, yeah, oh, sorry. For no gas in Unit 4E and no working passenger elevator in the building. Again, it's 112-114 West 14th Street for no gas in Unit 4E and no working elevator in the building. I'll just note about enforcement more generally. Our enforcement attorney and our enforcement inspector are in essentially daily contact, reviewing complaints together and assessing from both legal and practical standpoints what kind of issues our ability to enforce, what we can address. We've arranged some joint inspections with DOB. We've arranged some joint inspections with DOB in areas that are outside of our abilities, and we're also trying to develop a list of reliable and useful referral contacts with other agencies for areas that we can't, matters that we can't address. We do get referrals on Loft Board buildings regularly because they're Loft Board buildings. But to the extent we can't address it, we very much want our customers and constituents to find the help they're looking for if available if we cannot. With respect to rulemaking, the rules that this board, the proposed rules that this board passed in May are under review by the law department. And they also did go to the mayor's office, who advised that they seemingly and likely have no comments. Of course, they surely reserve the right to look at the final product that comes back from the law department, but those are under review. I was suggested in a prior meeting that we give an update on the Soho no rezoning when possible, and there was a lawsuit brought by community groups that was concerned about the rezoning, and that was dismissed earlier this month. And community board review is underway, and the updates on that process are available on the New York City Planning website. The community board review goes, according to that website, through July 26th. I have some cases, updates on litigation, 4 of them, 4 decisions. The first is Hughes versus the New York City Loft Board. So index number 150395/2019. And here the petitioner was the sublessor of the first floor unit at 401 White Street and filed an Article 78 to challenge two loft board orders, number 4714 from November of 2017 and 4820 from November of 2018. And in those orders, the loft board rejected Oath's recommendation and denied protected occupancy status to petitioner because it did not use the unit as a primary residence. Records showed that the petitioner had left the apartment to live with his girlfriend and rented the apartment to others. The court denied the petition and found that the loft board was not arbitrary or capricious. The petitioner also argued that the 2019 amendment to the loft law and the addition of 2816 permitted him to reapply for protected occupancy status. And the court found that that matter is not ripe for review, as the loft board has yet to make a determination on that issue. The second case is 475 Kent, owner versus New York City Loft Board and Julian Bozeman, index number 152162/2001. The mayor and owner filed an Article 78 challenging the Loft Board's determination in Loft Board Order 4987 from June of 2020. And that order invalidated prior tenant sale of rights because that prior tenant was no longer a residential occupant of 473 Kent Avenue at the time of the sale. The Loft Board rejected an OVLJ's recommendation and granted Bozeman a new tenant protected occupant status. Owner argued, amongst other things, that the Loft Board had failed to consider post-trial briefs submitted to Oath by both parties. On June 2021, the court disposed of the matter as moot after a stipulation of settlement was reached by which the Loft Board vacated Order 4987 and remanded the matter back to itself for review in order to ensure that all relevant documents and briefs were duly considered. The third decision and litigation update is in the matter of the application of the estate of Bickman, index number 101209/2017. Here the petitioner, which is the estate of Minda Bickman, filed an Article 78 asking the court to annul Loft Board Order 4667 from April of 2017, which valued the decedent tenant's fixtures from a unit that was located at 595 Broadway in Manhattan. And the order refused to turn over possession of the unit to the estate's administrator. The Loft Board relied on available records and testimony that the deceased tenant had given in a 1982 mayor's hearing on Loft Board increases. The Loft Board also relied on a decision on the specific matter of possession that was rendered by the New York State First Department Appellate Commission. The court denied all claims, finding that the Loft Board's determination was consistent with statutory language, was not unreasonable or irrational, and was neither arbitrary nor capricious. And the last case update is the decision, Brigham versus New York City Loft Board, index number 100043/2001. And here, the petitioner was a residential tenant of the third floor IMD unit at 72 Warren Street in Manhattan. Filed an Article 78 petition and a motion for a stay, asking the court, amongst other things, to stay or stop an ongoing narrative statement proceeding that was initiated for the building, and to annul the Loft Board's staff's decisions that were made during the narrative statement process, and to direct the Loft Board to conduct a narrative statement proceeding in accordance with its rules. The court denied both the petition and the motion for a stay, finding that the petition was premature and that the petitioner had failed to exhaust administrative remedies. The narrative statement proceeding is currently ongoing, and the Loft Board staff has not issued certification for this proposed work yet. In addition, the Loft Board is yet to make a determination on appeal applications, which petition was separately filed with the Loft Board. That is all I have for my executive report right now.
Thank you, Mr. Schultz. Is there any questions for Mr. Schultz? Mr. Delaney?
With regards to the letter that you sent to the owners, with regard to the letter that you sent to the owners, could you provide the board members with a copy of that letter?
Certainly, yes.
Thank you. And I will be requesting copies of some of those decisions, but I'll do that via email.
Certainly, yes.
Any questions? Yes.
It's not a question, but it seems like a good place to talk about it. In previous meetings, Mr. Barowitz has brought up the topic of the Soho NoHo rezoning and how the loft law is rarely talked about. So I went to the community board the first public presentation by the Department of City Planning to Community Board 2 in Soho about a month ago. And I actually took a picture of the slide where they talk about housing. And this is the Department of City Planning, so they quantify the housing in Soho as approximately a third of just what they consider plain residential units. A third are loft law units, and a third are joint living work quarters for artists. They talked a lot about the loft board, so if anyone's following this or wants to follow it, the loft law and lofts and loft tenants are talked about quite a bit.
Thank you.
Any other questions for Mr. Schultz? Thank you, Ms. Rosen. Mr. Delaney?
Now, I mentioned this earlier, and I guess, again, this is as good a place to bring it up. Since maybe 4 years ago, 5 years ago, we started having what we call a private meeting to discuss cases. It starts an hour before the public meeting, and I appreciate the executive director has a concern that the public section of the meeting should ideally start close to 2 p.m. for the convenience of the public. The problem is that the last couple of caseloads that we've had have been relatively simple, and they still take an hour. And there have been times in the past when the discussion session, maybe that's a good name, discussion session, has gone as long as till 2:30, 2:45. But clearly, the interest of the applicants is not served if the board members in that discussion are under time pressure. So I don't know what and my opinion is if you want to do it private, you have the right. I was against it philosophically, but clearly former Executive Director Balsam articulated a valid legal argument to have that meeting private. But if you want to do that, we really should think about a mechanism where we can balance the needs of the applicants versus the needs of the public, whether that's having the private meeting on a different day or significantly earlier. But when we hit some really gnarly cases, which is undoubtedly going to happen sometime in the not too distant future, it's just not going to work. So I point that out.
Chuck, wasn't there a time we actually had it for an hour and a half and started it at 12 noon? I thought it seemed like we did for a period of time.
It started, it's always been loud.
Okay. I mean, anyway, that's a possible option. add a half an hour and see if, that doesn't help us out.
Yeah, thank you. I'll just, go ahead.
I was going to say, we'll leave that to Mr. Schultz to figure out.
Yes, and so, just to illuminate anyone who might be curious what this is about, there is an opportunity and need for the board to speak with its lawyers, myself and others, and so that is what that time is about. It is about conversation between the attorneys and their clients, which is the board. It is not the time for the board to discuss. That is what this session is for, and so that's part of why it came up, is because we were, emphasizing that for some members and such. And so to the extent that there is a more workable way to do it, I'm going to be thinking and listening for that, because I do think that is valuable time. There's certainly nothing patently required about the timing of it or the nature of it. I shouldn't say the nature. There are things required about the nature, about the location and time of it. The nature of it is very important, actually, in that it is conversations with the attorneys, not conversations amongst the members, which is what this time is for. So, yes, thank you for bringing that up, and certainly will be thinking and listening about better ways to do that.
Thank you, Mr. Schultz.
Thank you. Again, there's no other questions for Mr. Schultz, right? So we now turn to an agenda item here, is the sales of rights under MDL 28612. Mr. Delaney had requested time for discussion on this issue. I now turn it over to Mr. Delaney for discussion of sale of rights under MDL 28612.
Thank you. This was prompted by the fact that we have struggled since sale rights first started taking place after the Loft came into existence with getting the sale of rights documents from the owner, keeping track of them, the by our designation that the staff developed at some point in time as a way to indicate the status of units, which I think is principally shared with the owner when the renewal goes out. But particularly in the past decade, 28612 sales 28612 sales have become very contentious, and we've had loads of cases, including on Tocket. Was it a sale? Was it a valid sale? Was it a real sale? Was that person entitled to sell? So it would seem to me, and the reason I suggested this is maybe there's a better way to keep records or not keep records. So if you have somebody, an owner saying, well, I've been getting registration notices that this was a by our unit, and that means it was bought out under 28612, but now you're telling me it's not, and this is terrible, and whatever else. The whole by our convention was something that the staff developed without any real consultation with the board members. As today I learned the hold principle is, but we'll save that for another time. So I would be interested in spending a little time at this meeting exploring what we can do to make, I guess, the logistics of receiving, filing, noting the sale of rights in a way that would be clearer and more helpful for everyone. In addition, the cases on the agenda, several of them involve 28612 issues, and we do have a rule that's pending that's now with the Department of Law, which would significantly change 28612 by requiring that the price paid be disclosed in the sale document rather than redacted. Today, we have a case on the agenda which is most remarkable in that 18 units, apparently all the units in the building were bought out within the span of 5 months, and we have all the sales of rights with all the prices blacked out. That's going to change assuming we adopt this rule. So as 28612 issues occupy more of our time and energy, I thought it might be helpful for us to have a discussion about what we're doing, why we do it, how we might do things better, etc. So.
Yeah, I'm indeed happy to respond and share on that for sure. Before I do, I will yield the conversation to anyone else who wants to share, ask, or comment first. Oh, sorry. I do have comments, responses on that, but before I do, I'll yield the microphone to any of the members who want to add or share or anything like that. Okay. I agree with Board Member Delaney that the sales of rights are kind of an issue of importance and interest, perhaps now more than ever, and not having the history as everyone, as others. I don't know the changes in development over time, but I will share what I've experienced as I entered this world of law board and 28612 cases and litigation and reviews and filings, and hopefully some of this will be enlightening and maybe be fodder for some of the conversation that Mr. Delaney suggests. The Loft Board staff receives applications that are sales forms that are filled out and signed, presumably and hopefully, by the parties, and then attached to those are sales agreements where the tenant has sold their rights to a unit, thereby deregulating it. And we do have a system by which after that is done, I'm going to use the word done right now, with an asterisk next to it, our system changes it, the labeling of it. And I do not think that labeling is part of the rules of law. It is an administrative activity to keep track of things. That's my best understanding. What I stepped into was a process that I believe Ms. Balsam was initiating, which was a review of these filings and the sending of a letter to the owner saying your filings have been accepted, or the sending of a letter saying we've reviewed the filings and additional information is requested. Or I believe there's administrative determinations rejecting the sales filing. And so I've seen examples of all of those. And I have now inherited a universe of forms and filings that are currently under review. And we have an attorney who is reviewing them according to the criteria under the rules, as well as with an eye for the things that have spurred litigation, which are always going back to the rules, but because they're litigation-based interpretations of those rules. And so what I seem to have received, which is a good thing, I think, was perhaps a not fully, I don't want to say fully functioning, because I actually think, again, my predecessor did start doing this, but I don't know if the universe, the industry, the practitioners, maybe this board, had an appreciation for this, that this was happening. And so, and I could guess that the reason Ms. Balsam started doing it was because we were seeing these older cases where years and years later, our staff is trying to compile a record to clarify whether this sale happened or not. And I think the thinking was, and mine is too, is that if we can do that now, we will thank ourselves later. And so that review is being done by our staff now. And that review includes, some fundamentals of, checking to make sure the space is designated as an IMD, seeing if there's open harassment dockets, looking at code compliance deadline, the building's code compliance deadline status and deadlines, looking to see if there's a prior sale of record for that same space, looking at the forms unto themselves, that they were completed and dated and signed, and looking at the timeliness for enforcement purposes, reviewing for the things that are required, the consideration, the signatures, the references to the MDL. So that review is happening, and we picked it up, and because I guess fortunately, very early on in my time, I was reading these cases and thinking, and I get some good advice from the staff, what they kind of learned, and then hopefully we are helping our future selves not see these situations in the same way. I hope that's helpful.
Thank you, Mr. Delaney. Are you finished with your presentation?
Well, I guess what I take away from your comment is that you're still kind of looking at this, both giving scrutiny to 28612 filings as they come in, and presumably thinking about, is there a best practice here? Are we following it? Is there a way we should modify it? So I guess in particular, my interest would be how the public, the owner, the tenants are served by having the by R designation included in the registration. Is that more helpful, or does it promote more confusion? And how does that track with, they filed something, it's being reviewed, but now the registration's got to go out. What do we do? So I guess that's the key question at the moment.
And the disconnect you just described has happened. Someone has done a filing, it is in our possession and within our review, and the owner received their registration and asked, why is it this way? And not having been here the whole time, I can't be sure, but I do recall you, Mr. Delaney, you saying last time that these types of sales maybe weren't as common or as important or prevalent going back historically. So I think it's possible that our constituents, our owner, are not as, they perhaps never experienced that acceptance or rejection letter that I saw Ms. Balsam had started to do at a certain point in time. So it's not maybe, and then a delay in the executive director, a COVID delay created just a time of, just an additional amount of time where this wasn't happening with the frequency. So I think it's possible this has to get, as you said, honed a little bit, or you could say honed, but reviewing it to see what's the best practice. But then it needs to get into the zeitgeist, into the ether a little bit. And as it does, we receive feedback from owners who are, I believe, in good faith, legitimately not clear on why it is that way. Some of them may have very legitimately experienced, I said it, and that was it. I never heard anything. That seems to have changed in the relative recent history because of, again, the kind of cases we've seen. So the new notes are taken insofar as how the logistics and administration, how we can do the best by ourselves and all parties. Thank you.
Thank you.
Thank you, Mr. Schultz. Thank you, Mr. Delaney, for leading the discussion. We now turn to a vote on cases. A little bit too aggressive there. Okay? So there are two cases on the appeal and reconsideration calendar. The first case is tenants of 400 South 2nd Street, and the address is 394 through 400 South 4th South 2nd Street in Brooklyn. And that docket number is AD 0109. Ms. Lee will present this case.
Thank you, Chairperson Hilton. This case involves an appeal application in which the tenants of the building challenge an administrative determination dated July 28, 2020, that was made by the then acting executive director of the Loft Board. In the administrative determination, the then acting executive director, among other things, concluded that the building was exempt from the narrative statement process pursuant to 29 RCNY Section 2-01D2 IIIA. On appeal, the tenants assert that in determining whether the building was exempt from the narrative statement process, the then acting executive director committed an error of law. This proposed order disagrees. The record shows that the following conditions for exemption from the narrative statement process, as set forth in 29 RCNY Section 2-01D2 IIIA, were satisfied for the building. Number one, on or before June 1st, 2012, a building permit was issued for legalization work. And number two, the building permit remains in effect or is renewed without reinstatement or amendment of the underlying alteration application and legalization plan until the final certificate of occupancy is obtained. On February 11, 2011, the DOB issued an Alteration Type 1 or Alt 1 permit to legalize the conversion of commercial spaces in the building into residential spaces and to obtain a new certificate of occupancy. This occurred prior to June 1st, 2012. Accordingly, the first condition was met. As to the second condition, at the time of the issuance of the administrative determination, the Alt 1 permit was not in effect because the Alt 1 permit had expired on August 9, 2019. However, where a building permit is not in effect, the second condition may be satisfied if the building permit has been renewed and continues to be renewed without reinstatement or amendment of the underlying alteration application and legalization plan. Here, records maintained by the DOB indicate that by the time the administrative determination was issued, the Alt 1 permit had been renewed without reinstatement between 2011 and 2018. In addition, the last renewal permit in 2018 had expired on August 9, 2019, thereby setting August 9, 2020 as the deadline to renew the Alt 1 permit without reinstatement. At the time of the issuance of the administrative determination, the one-year period to renew the Alt 1 permit without reinstatement had not lapsed. Furthermore, records maintained by the DOB reveal that by the time the administrative determination was issued, 4 post-approval amendments, or PAAs, had been filed for the Alt 1 application. However, none of the PAAs triggered the right to a narrative statement process under 29 RCNY Section 2-01 D2 IIIA. The PAAs either occurred prior to June 1st, 2012, were never approved by the DOB and/or were withdrawn, or contained no substantive changes to the Alt 1 application and to the legalization plans. Accordingly, the second condition was also met, thereby exempting the building from the narrative statement process pursuant to 29 RCNY Section 2-01 D2 IIIA. With respect to the renewal of the Alt 1 permit in 2015, the tenants contend that the Alt 1 permit had lapsed in excess of 1 year between 2014 and 2015, and thus the owner should have been required to apply for reinstatement in 2015, which would have triggered the right to a narrative statement process. This proposed order finds that the tenant's claim is unavailable. Although it may be argued that the DOB violated its own procedures by allowing the Alt 1 permit to be renewed without reinstatement, the Loft Board is not authorized to review the DOB's decisions for correctness and to supersede them if they appear to be in error. The Loft Board may only determine what actions have in fact been taken by the DOB. In sum, this proposed order holds that the facts found by the then acting executive director in the administrative determination are supported by substantial evidence in the record, and that the then acting executive director correctly applied the law. This proposed order denies the tenant's appeal.
Thank you, Ms.
Thank you, Ms. Lee. Is there a motion to accept this case? Mr. Roche, is there a second?
Ms. Rosen.
Ms. Otto? Ms. Otto has seconded. Thank you. Does anyone have any comment on this case?
We have this remarkable situation where the loft board is a separate entity, except when sometimes it's part of the Department of Buildings. The chair of the loft board is the commissioner of the Department of Buildings, since then Mayor Bloomberg issued the executive order that sets it up that way. Here it appears that this owner was very prescient. He had a building that appears to have had a lot of converted loft residences, and he actually filed for an all in February of 2010 before the loft law was expanded in June of 2010. This created a situation where the tenants don't have the benefit of their statement conference. Then we get to this period in 2015 where apparently the Department of Buildings allowed the owner to renew the lapsed permit. Even though a full year had gone by, which technically should trigger reinstatement. So I feel that we're in a situation where I'm not so sure we wouldn't have the discretion to take a different position. What I fear will happen here is that the tenants, probably under advice of counsel, may seek to raise the issues regarding legalization by bringing an unreasonable interference case or by denying access. The concept in the narrative statement is one of the most remarkable things about the loft law, and it's worked very well. So, as I ponder all this, I think I'm going to vote against this proposal.
Thank you, Mrs. Lynn.
To add a few points, yeah, this case is quite the morass. There was also some questions raised about PA filing to amend, to merge the zoning lots. There are 3 different professional applications. So there's a number of other issues that we were looking at or have been looking at today on this case. I'm with Mr. Delaney. I'm going to vote no.
Thank you.
Thank you both. Are there any other comments on this case? Without any comment, any other additional comments?
Mr. Rivera.
Ms. Rivera, could you please poll the board members?
Mr. Roach.
Yes.
Mr. Delaney.
No.
Ms. Rosen.
No.
Ms. Otto.
No.
Ms. Rajan. No. Chairperson Hilton.
Yes.
2 in favor, 4 against, 3 absent.
How many in favor?
2.
Thank you. This motion is not passed. So this case will be revisited. The next case is MZBJ Holdings LLC, and the address is 250 Moore Street in Brooklyn. New York, and that docket number is R0386. Mr. Schultz will present this case.
Case number 2, MZBJ Holdings LLC, 215 Moore Street, Brooklyn, is a reconsideration, in the matter of a reconsideration application filed by the owner of 215 Moore Street in Brooklyn, New York, which seeks reconsideration of Loft Board Order 4980, dated May 21st, 2020. Loft Board Order 4980 found that tenants of units 204 and 206 were protected occupants and found that they were entitled to rent overcharge awards. Owner now challenges Loft Board Order Fine 4980, arguing that the Loft Board erred in finding that purported sales of rights by prior tenants were invalid. Owner argues that previous deregulating events purportedly occurred pursuant to 286-12 sales of rights. This proposed order disagrees and supports the finding of the underlying order. First, the proposed order finds that the tenant applicants were not required to allege fraud or unconstability for the Loft Board to render its determination, because the Loft Board possesses the authority to scrutinize the validity of sales of rights as a matter of public policy. That authority exists as a matter of public policy, not merely amid allegations of fraud or unconscionability. Second, the proposed order rejects owner's assertion that the purported sales of rights were valid because consideration was sufficient. This proposed order finds that the underlying order was proper in determining that the purported sales were invalid based upon factors unrelated to consideration. Third, the proposed order rejects owner's assertion that the lateness of the sales filings was a significant factor in the underlying order. The proposed order asserts that other factors were determinative in the board's finding that the prior sales were invalid. Fourth, the proposed order finds that the underlying order was correct in determining that the sales of rights were invalid because the owner failed to prove that the sellers intentionally relinquished a known right. Here, the validity of the sales agreement was an affirmative defense to be pled and proven by the owner. The documents and testimony provided failed to show knowing waivers of lawful rights. The sales agreements lacked a proper reference to multiple dwelling law, 286-12, and the sales forms lacked signatures. Testimony of the owner's managing agent was not able to credibly resolve these deficiencies. Fifth, the proposed order rejects the owner's argument that the tenant applicants were never protected occupants, despite an explicit stipulation made and oath establishing such. Owner again asserted the validity of the prior sales of rights. The proposed order states that because the prior sales were invalid, this argument has no merit. Finally, the proposed order rejects owner's request to reassess the overcharge amounts based on water escalators. Because this argument was never raised prior to the current reconsideration application, this portion of the application was denied in the proposed order.
Thank you, Mr. Schultz. Is there a motion to accept this case? Mr. Delaney, is there a second? Ms. Otto. Thank you. Are there any questions on this case?
I just have one question. On page 5, the last paragraph, it states that the owner is further undermined by the fact that between 2011 and 2016, its annual Loft Board registration renewals the owner certified that units 204 and 206 were rent regulated, even though owner allegedly purchased the rights to the units in 2011, 2012. We're still evolving our handling of cases in public, so I am going to ask the executive director a question, which he may or may not answer. My question is, was the owner's certification of that by signing the registration with having these 2 units not designated by R?
I do not have that record directly in front of me, so I don't want to misspeak, which would be the best thing I need to do. But my understanding of the registration documents that go out have an indicia of this regulated versus deregulated status, and that the response includes a statement of certification as to those various facts and details within the registration documents.
Thank you.
Thank you, Mr. Schultz. Are there any other questions or comments on this case? Absent any comments, then Mr. Vera, could you please poll the board members?
Mr. Roach?
Yes.
Mr. Delane?
Yes.
Ms. Roseman? Yes. Ms. Adam? Yes. Ms. Rajan? Yes. Chairperson Hilton?
Yes.
6 in favor, 3 absent.
Thank you, Mr. Rivera. Motion is passed. There are 3 cases on the summer calendar. They are voted on as a group, and these cases are 475 Kent Owner LLC. The address is 473 through 493 Kent Avenue, Unit 609, Brooklyn, New York. That docket number is LS0253. The second case, 475 Kent Owner LLC, as applicant, address 473 through 493 Kent Avenue, unit number 805 in Brooklyn, New York, LS0255. The third summary case, applicant is Crystal Heffernan, and that address is 250 Moore Street, that is unit 408 in Brooklyn, New York. The docket number is PO 0128. Do I have a motion to accept these cases? Ms. Otto, moved. Is there a second? Ms. Rosland. Does anyone have any comments on these cases? There seem to be no comments in these cases. Therefore, Mr. Rivera, could you please poll the board members?
Mr. Roach?
Yes.
Mr. Delane?
Yes.
Ms. Roseman?
Yes.
Ms. Adam? Yes. Ms. Rajan? Yes. Chairperson Hilton?
Yes.
6 in favor, 3 absent.
Thank you, Mr. Rivera. There are 2 proposed orders on the master calendar. The first is a removal case, and that is for applicant 269 Meserole Realty LLC. That address is 269 through 271 Meserole Street, Brooklyn, New York. And the docket number is LE0726. There is no staff presentation on the removal case, so do I have a motion to accept this case? Mr. Delaney? Oh, Mr. Tudor. Do I have a motion to accept the case?
No.
You have to accept.
Okay, we have to accept
Discuss
it.
it.
Do I have a motion to accept this case? And Ms. Otto is first and Ms. Rosen second. Comments on this case?
Yes, actually, we discussed this case at some length in the
Earlier session.
the super secret, none of your business session.
Attorney
And
Klein.
there seem to be some irregularities in the way the order is drafted, and we had some questions that there weren't immediate answers to. So I'd like to suggest that this be tabled till our next meeting.
Before I make that decision, is there any other comments on this case? Any other comments? Mr.
You also? I would also like to see it tabled for the same reasons.
Okay, Chair will table this case for the next meeting while staff answer some questions posed by the board members in our earlier private session. Where is it? Case 7, that's right. So the last case on the master calendar is SMCE Associates LLC as applicant, and that address is 329 Greenwich Street, New York, New York. The docket number is LS0260, and Ms. Lynn will again present this case.
Actually, it will be myself in the absence of Ms. Lynn. Case number 7, in the matter of the application of SMCE Associates LLC, is an access application filed by the owner of the building located at 329 Greenwich Street, New York, New York, against the residential occupant of the 8th floor unit. Owner seeks an order from the Loft Board directing the tenant to provide access, imposing a civil penalty of $17,000, and finding that the owner may apply for a rent increase based upon the cost of bringing the access application. The proposed order dismisses the owner's access application for failure to comply with the service requirements of the Loft Board rules for access applications. The Loft Board rules require that 2 notices be served prior to the filing of an access application. The first notice must be served by personal service or by first-class mail. If by first-class mail, it must be sent registered mail or certified mail, and a return receipt must be requested. Here, the owner failed to establish that its first notice was served in conformance with the Loft Board rules. The initial notice was sent via certified mail, but there is no indication that a return receipt was requested. At trial, a paralegal for owner's attorney testified that, based upon the certified mail receipt, it appears that no return receipt was requested. The granting of an access application carries significant consequences for the tenant, including intrusion into private space, the imposition of a civil penalty, and grounds for eviction. Therefore, the proposed order finds that the Loft Board's notice and service requirements for access notices must be strictly followed. As owner has failed to establish strict compliance with the Loft Board rules, the application is dismissed.
Thank you, Mr. Schultz. Is there a motion then to accept this case? Ms. Harlow, is there a second? Mr. Delay, thank you. Do you have any comments on this case? Absent, any comment? Ms. Rivera, could you please poll the board member?
Mr. Roach.
Yes.
Mrs. Delane.
Yes.
Ms. Roseland.
Yes.
Ms. Adam.
Yes.
Ms. Rajan.
Yes.
Chairperson Hilton.
Yes.
6 in favor, 3 absent.
Thank you. So that motion is passed. And that's the end of our meeting. Before I actually close this meeting, I would just like to ask any board member if there's anything that we're missing, anything that you'd like to say. Board members? No?
Just thank the staff for their work.
Yeah, as always.
Yeah, thank you for setting up this meeting, making it happen, and all the tech people.
Thank you. I would, I'll accept it on behalf of Mr. Schultz and his staff. I know there was quite a bit of ingenuity and planning and consulting with law and everybody else to kind of get this new format, that is old new format, back in place. I want to apologize to members of the public who had to wait a little bit on us and bear with the sound and maybe the audio and the video type of hiccups that happen, but we are kind of trying to make this new environment work for us as much as we comply with the open meetings law.
Mr. Chairman, I just also want to give a shout out to the tech people, in particular with the mics and the computers and all that. And then just ask if we believe this is going to be our new home for the foreseeable future, or if 22 Reed is still out there as a possibility.
Okay, yeah, I want to echo that too. I mean, our tech folks are superb, and they came in and they rehearsed with us during the week. This whole setup, came back and reset it up for us today. And so shout out to DOB IT folks. Really do appreciate it. Those folks. Facilities also, yes. I'm sorry, yes, thank you. Facilities who made arrangements to these rooms. So let me just give a little background on what happened leading up to this. We explored a whole bunch of different venues just to make this happen. First, we wanted to give the public and continue to give the public this opportunity to view this remotely. So even though the GoToMeeting, what you're looking at now from home isn't a requirement anymore, we wanted to keep it that way. So folks who may be still a little hesitant, or maybe because of the heat, want to come out, I think that's a great addition that COVID has given us. We take that lesson and we want to run with it. So we want to keep that available. So then that presents another issue, Wi-Fi availability for the setup. And a lot of the venues that we went to that could accommodate more people, we did not have the capability for Wi-Fi. So our facilities, our even DCAS and Department of Citywide Administrative Services and our IT folks had to scramble to make this arrangement with us, where we had an overflow room with camera, with video equipment, viewing equipment set up, and also try to do this so you can see it from home. So unless things change in the next month, in answer to your question, we don't want to go and experiment into another location.
Right.
And to see, we can only work and build on this, so we probably want to perfect this setup and not try to do something different unless things change and COVID-19 is no longer next month, or maybe mass restrictions are gone and whatever the politicians decide is best for us, we'll try to work within those constraints. So yes, so it seems to be that this will be the way it is next month, even though my word is not law. Yes. September, sorry, I said next month.
Is there no meeting next month?
No. So I'm going to read this closing statement, and it's all in there. I made sure I wrote it down. Any other comments? Any other questions?
I was just going to say, I'm so excited to be back with human beings and live people that if we had a meeting next month, I'd almost look forward to that.
One thing we can't do is hugs. We can't do any hugs. So this will conclude our July 15, 2021 Loft Board meeting. Our next public meeting will be held on Thursday, September 16, 2021 at 2 p.m. So there's no scheduled meeting for the month of August, as I said before. It will likely be held here again at 280 Broadway, but we cannot be certain at this time. When we have further information, we'll update the Loft Board's website and send an email update through the Loft Board announcement listserv. Thank you very much, members of the public. Thank you for your patience. Loft Board members, could you please sign and hand in your attendance sheet. Have a good summer.